Good morning, everyone, and happy Friday. It is June 20th, 2025, and we have a very special guest today, Miss Daisy Castro, who is the president of Legal Daisy, and she is a defense workers' comp attorney. And today we will be talking about all the good things, but in reality, it's not good, it's bad. If you guys have ever experienced workers' comp, especially in the state of California, it's a huge headache. And unfortunately, it's a big headache for a lot of industries. But for this specific topic today, we will focus on staffing in existence with the co-employment staffing, the relationships, the different relationships there can be between a staffing agency, an employee, a payroll company, the client, vendor, all those good things. So I'll let Miss Castro introduce herself. And if you guys have any questions, go ahead, pop them in there, and feel free to ask away.
Good morning, everyone. Thanks for the compliment and the intro, Rocio. My name is Daisy Castro. I founded Legal Daisy, but I have been practicing California workers' compensation for about 9.5 years. And yeah, no one ever comes to me when it's good times. I always get to see the bad stuff, unfortunately. And so usually when we finish something up, I go, I hope I never see you again, in the sense that I hope you never need me again. But yeah, staffing agencies, that one's always interesting. So let's dive into it.
Yes. So one of the things that you and I were discussing is the co-employment relationship. And I really want to dive into that and have your definition of co-employment, because I think that is something that gets it's complex, and especially when there is an injury that happened at a client's site from a staffing agency, but we all know that certain staffing agencies use different types of insurances. So you have your standard one, you have your PEO, and then you have your the AOR. So definitely it is, it's a big issue here. And happy Friday, Will. Thank you so much for joining us. But I'm going to let you, Daisy, define that definition.
Okay. In the legal world, there's never a definition. And I feel like any answer anyone can ask, you can assume that the answer is it depends. That's always our answer. I feel like every attorney that I talk to, that's our go-to phrase, because it really does depend. Everything is so dependent on different facts and conditions. But so we have in California workers' comp a relationship called general employment, and then we have special employment. And so one of the biggest issues that comes up is you have an employee, they get injured, and then nobody knows who's supposed to take responsibility sometimes. And that comes from different perspectives. One, it can be that the contract says one thing, but the parties, meaning the staffing agency and whoever's handling things for the job site, don't have the same understanding of what the contract says, or the contract's so old that things have become murky.
Can you give us an example of like what you mean by an old contract and the words in that old contract?
So it has come up several times where the staffing agency, they believe they have this contract that said that the job site was going to provide insurance coverage for these temporary workers. Well, maybe in the last 3 to 5 years, there's been a new HR department or a new company that's handling HR for this company, and they either didn't look at the contract or somebody just told them what the setup was, and they make changes to their coverage and they don't cover the temporary employees. And then we get stuck with, well, the staffing agency wasn't providing work comp coverage for them, and the job site wasn't, and they both thought the other was. So now we have an uninsured employer situation.
Then let me ask you, in that type of situation where there's obviously a big misunderstanding, who would be responsible for that if it happened, if it was their, the staffing's employee, but they got hurt at the vendor's location?
Um, it depends, but both the
Mhm.
general employer and the special employer have exposure on a claim like this. So the ideal scenario would be that, the attorney for the job site and the attorney for the staffing agency are going to work together and say, hey, this is what it's going to end up being. Like, let's work together and try to collaborate and knock this out. That would be the ideal situation. Does that happen all the time? No. Um, Nobody wants to take responsibility, especially when they truly believe that the other entity was going to provide the coverage. And so it turns into a blame game, which I don't think helps anyone, because you end up spending more money, incurring litigation costs, fighting between each other instead of trying to resolve the actual case. But then it gets complicated by other issues. Sometimes, you know, the employee for some reason believes they were operating as an independent contractor, or the job site thinks that they were no longer operating under the staffing agency's control, and they were an independent contractor, so we didn't have to provide work comp coverage. There's just a lot of nuances that can come into play.
Yeah, and you definitely have seen that. And then can you also touch on the point you said special employer?
So usually the job site where they're played, if we're talking specifically about staffing agencies, will have some kind of special employment relationship. Usually what the board uses to determine if there is a special relationship, the big one is who has control over the employee. So who has control about where they show up to work, when they show up to work, what they do at work. So job duty, schedule, location, those are all things that are taken into consideration. Another big one is who is providing the tools that they need to perform their work duties. Is it the staffing agency? Are they bringing it in on their own, or is it the job site that's providing them with that? There are other factors that they use depending on the type of work that they're doing, the period of time that they're working at this job site. Sometimes you have these people that are placed by the staffing agency that are there for a couple days, a couple months. It could even go into a couple years, and then they transition into permanent employment. And then you get hit with the CT, right? And then you're trying to move around that CT period to see who is actually liable for that injury.
Yeah, let's touch on that because that's actually a big pain point for all industries in California, but specifically in staffing, because there's some staffing agencies that only do temp hiring. So it's seasonal, they're in and out, in and out. And there's other ones that do temp to permanent. So maybe they have it changes. It could be from 90 days to 30 days. And sometimes because the vendor is like, oh my God, I really like the way so-and-so is performing, I would like to have them. And there's different interchanges, especially when it comes to the medical side, nurse staffing. But let's touch on the topic of cumulative trauma, of how that would be handled if the employee was once a staffing employee and then converted into a permanent employee to the vendor.
So once they're a permanent employee, I would most often not, the liability is going to shift to the job site who's now the employer. It's not a special employment anymore. They are the employer. But with this cumulative trauma, you're looking at that last year, the year preceding when they had knowledge of the injury and disability. But as we all know sometimes they get pled for these longer periods. It'll be like 2005 to 2024. And so it is important to determine where the cutoff was for that general employer relationship from the staffing agency's perspective. And then we have to look at our contracts with the job site to see who had taken on responsibility for providing the workers' compensation coverage during that period. But it's also important to remember that both the general and special employer, if they are, within their period of liability, they are both jointly and severally liable for these injuries. So if one is uninsured, it falls completely on the other, or it can fall, I should say.
Yeah.
So it's important to keep that in mind. And so, really quick digression, but another issue that I've seen several times is where either the job site or the staffing agency says that they will provide the coverage and then they don't, and their coverage lapses, and the other party's not aware of it. And so they're operating for years with these employees and they have no workers' compensation coverage. And so, that becomes an issue because the entity that does have coverage, then they have to take responsibility to some extent. And it becomes a toxic relationship because they're not happy that the other party was dishonest with them and didn't tell them that they were no longer providing coverage. And so the one that does have coverage is taking this unnecessary risk because they're uninformed of taking on these employees that could get injured.
Yeah, and that's actually one of the hot topics that I was at the Staffing Association conference about 2 weeks ago in Irvine, and that was one of the main hot topics because unfortunately there's a lot of staffing agencies that have the bad ones who have the bad reputation of going uninsured or partially insured, and unfortunately the vendors have been in that side where they become liable for that injury. Now, how would you, for what advice do you have for vendors on the opposite side and how they could protect themselves to make sure the staffing agency they're hiring has insurance, or what's one way they could protect themselves?
So, I mean, I guess this takes me out of my realm, so I can only give my opinion on what I think would help. And it would come from whoever's managing HR and managing these contracts. You have to verify that these insurance certificates that you're getting are real. Because I've seen that. I've seen where a business is providing a certificate of insurance so that they can prove that they're providing the coverage that they say they are within their contracts, and it's actually wrong. They're just changing the policy, moving the policy period over to show that they renewed it when they did not. I mean, obviously that could be fraud. But I think if you are requiring the other party to provide the coverage and they're providing you the certificate, I think it would be pretty easy to just call the insurance company and confirm. I mean, if there's a reason to question it, it doesn't hurt to take that extra step because it can save you in the long run.
Yeah, and that's actually the advice we gave to the public. You guys, as vendors and clients, you guys have the absolute right to call an insurance company to verify if there's coverage, and then you just have to explain yourself why you're calling. It's because you have hired this specific agency to do a job, and you want to make sure that they have coverage in place, and that's it. And they will give you a yes or a no, and it gets very complicated when there is when certain certain staffing agencies are in a PEO model. And for those who don't know what PEO is, a PEO is when you're doing both workers comp and payroll, because there's been situations as well where the staffing agency may have this PEO active, but that employee is not on payroll. they have the payroll with a separate payroll company. So the employee is getting paid, but they're not insured under the workers' comp. And then when the lawsuit comes in and they say, "Well, provide me with the insurance," and the insurance company goes, "Well, we never had so and so on our record, so we're denying the claim because it's non-existent payroll." And now the vendor is stuck with this claim.
And it adds another layer to the complexity when you have these disagreements, because now you're bringing in the payroll company. So now you have three different entities. And, even worse if they end up joining UEBTF, because then you have them, added to the party, and you have four different people pointing the finger. So it can turn into this big web of uncertainty. And it's just best practice to double check, confirm that the coverage is there and that everybody knows who's providing the coverage.
Absolutely. And so from the staffing side, when they're sending over their employees to the vendor, and the employee gets injured because the vendor's place is quote unquote unsafe, or they did something that, or their site is not safe, it's not protected safely. In that sense, I also have had questions from staffing agencies. Well, it wasn't me who caused it. It was my vendor's unsafe job site or unsafe site that caused this injury. But at the end of the day, it's still your employee. It's still your employee, and it goes under your workers' comp.
Yeah. So California's no fault system. You can get pretty far in it either being the injured worker's fault or someone else's fault that causes the injury, and they are still entitled to workers' compensation benefits. But there is an opportunity to explore contribution, reimbursement, subrogation with the other party. And so if that is something that you want to do, you want to make sure that the workers' compensation firm either does subrogation or find a subrogation attorney that can help walk you through that. Also, if the other party is already joined and they're already in the mix, or after the fact, you can join them, but you can look toward contribution or reimbursement based on, you make your arguments of fault, safety issues, that they're the ones that caused it, and that those issues, contribution, they between co-defendants get resolved through arbitration.
Yeah. And then can you explain to the audience, for those who might not know, what that means with contribution, subrogation? Because as you know, subrogation isn't handled to the end of the claim. So can you maybe explain just, in brief terms what that means?
So I guess I'll do subrogation first. And when we open up a file, we look to see if there's any opportunity to explore subrogation. Sometimes we request the carrier or that the claims administrator conduct a subrogation investigation for us to determine if there's anything there. And sometimes the injured worker might have a separate claim, like a personal injury claim against, I guess in this case, we're saying the job site was at fault. So against the job site, they might have their own personal injury claim. So when there's an opportunity for subrogation, you want to look into it early, especially if they already have a personal injury claim or a civil claim against that party, because you want to get involved in that claim as soon as possible. You don't want to wait and then they settle that other claim and the settlement money goes out, and then you come back and go, oh wait, but we have this work comp thing and we want to assert a lien on this. It might be too late. The money's gone, So you want to get in early, because that way when they're looking to settle the claim, everyone's aware that there is a possible work comp lien. Or if it's already, if you already have the total amount, you want them to know that amount, because then once they're notified of that lien, they have to reach out to you before
And
they
then,
settle.
and then let me ask you for the audience that's listening right now, can an employee file two claims at the same time? A workers' comp claim and a personal injury?
Yes.
Okay.
Um,
And second note on that, because I've seen it, and then I see it more on the construction side, right? Like someone, like I'll give you an example. Like this guy was walking down, he was walking down some board, and unfortunately, it wasn't covered right by the concrete guy. So he fell through, and he fell through I believe it was like 7 feet or something. But he fell, landed on his arm. He did break his arm. They had to get surgery. Long story short, the guy. Luckily, the guy was young. He was like 21. But according to the witnesses, they said that they saw the guy smoking pot before this stuff happened. So it's messy. It's very messy. But long story short, the work comp ended up being really hefty. In the settlement, it was around 300 grand because
okay.
of the surgery, and of course, you end up filing for stress, blah blah blah, and all these other things. And then he went, while that was open, they went after the general contractor, not the subcontractor. They went out after the
Mhm.
general contractor and the owner at the job site. And then those guys had to go down to the subcontractors.
Wait, and this was in the personal injury claim they went
Yes.
after the general contractor? Okay, okay, got it. Yeah, so okay, the way it works, I don't want to say too much because I'm always
Yes.
weary of giving the other side like more information and more ways to come after employers. So okay, so in personal injury, you have general damages and special damages. Apparently, we like those terms in the legal world, general and special. So when you have your medical bills, right, that's a fixed amount. You can see it. You get those invoices from all the medical providers. Um, so that is something they can recover in their personal injury claim. They can also recover money for pain and suffering.
Right.
In workers' compensation, we don't have pain and suffering. And so
Right.
you have your work comp claim, and then the carrier ends up paying for all this medical treatment. So when you file a work comp lien on a personal injury claim, you're trying to get reimbursed for those medical bills that you've paid, all that treatment that you've paid for, and disability, because you can get wage loss in your personal injury claim. So they're going to use all that treatment, all that money spent on treatment and all those disability payments to create the number for their personal injury claim value. And then on top of that, they get to seek pain and suffering and future pain and suffering. So by going the subrogation route, you're trying to so say that case you said settled for 300. So let's just say that in the personal injury claim, they were able to settle it for double, let's say 600. Well, you can go in and request that 300,000 as your work comp lien, because they don't get to recover twice for the same thing, for the medical treatment and the disability benefits that were issued, because that's wage loss. It factors into wage loss. And so if you get in early enough, there's a good chance you can get that 300,000 back, or even half of that, because sometimes they'll try and negotiate because the personal injury attorney needs to get paid, and the injured worker needs to have some net. They need to net some money from that settlement, and so that's why you want to get into subrogation, because they're using all the money spent on that work comp case to beef up their personal injury case value. So you want to get in and get some of that back.
Yeah. And like you said, I think that where they win is on the pain and suffering, especially if it's found negligent, because I mean, at the end of the day, if that was caused because of a negligence on whoever caused it, it's still negligence. And it's the complexity of that is the same complexity that you'll find in the staffing. That's why I always say staffing and contractors are very similar in that sense, because you are leasing your employee over to that vendor, and that vendor has a different role of policies and procedures, and also the job site, it's different. So like every time you're sending your employee over there, you're exposing them to all of that. And I think what really goes on in the staffing side, because it's people, you also deal a lot with the labor law issues, where they might feel they're being discriminated, not getting their breaks on time, or they're having issues with the supervisor because the supervisor is treating them differently because they're staffing people and not the employees.
Or also the employees themselves sometimes don't know who to go to
Oh
for
yeah,
you.
all the
So
time.
for example, if you've been there for a while, right? Let's say you're doing some kind of admin work and you're like, oh man, like now I'm getting this numbness and tingling in my wrists and this and that. Maybe I should get an ergonomic keyboard, and they don't know if they should be going to the job site, whoever their supervisors at the job site, versus going back to the staffing agency and saying, I need this and that. And they might go to the wrong person, and they'll just say, oh well, it's not us, so I'm not going to do anything. So
Yeah,
the roles need to be communicated and clarified. I think that would make it easier for everyone to know who to go to.
most definitely. And one of the hot things that I've seen a lot, and it's been ongoing for probably the past 10 years, is stress. Stress, psych issues is now like the thing, where I've
Yeah.
seen a lot, especially with post termination.
Yes.
They want, like, a faster settlement. They'll say, they're hurt from head to toe, but they're stressed out. And because they're adding that stress component, now their claim has increased. And usually, the attorney is always going to try to fight for that QME.
Yeah, and I always say I'm going to go crash one of these applicant attorney conventions, because I always get curious as to why certain things are done. But I know the trend right now is to file your ortho CT, from now until, or from, just January 1st, 2024 to January 1st, 2025, and then file a separate psych CT for January 2nd, 2024 to January 2nd, 2025. It's like one day later. Um, I'm very curious to know what the end goal is with that, but I know that's the trend right now. They're all coming in like that. It's just
Oh yeah.
the CT and then the one day off psych CT, and it's just stress and psych.
Mm-hmm. And then what's the statute of limitations for accumulative trauma for those that don't know?
Well, it's 1 year, but I caution you that statute of limitations is a weak defense. I hate saying it. I will argue it, but it is a weak defense, especially for cumulative traumas, because you need to establish knowledge of the injury and disability. And so if we just want to look at these psych CTs that are being filed, right, solely psych, it's very possible that they did not know that they had a psych injury until after they were terminated, and they like sat with that, and maybe they never took time off. They never took a mental health day, or they never said they took a mental health day. And so you're not going to be able to establish that they had both knowledge and disability at a time prior. But that's where we come in when we are taking depositions, when we're going through personnel files, which is a little bit harder when you have staffing agencies, but definitely in depositions, and getting medical histories are so important, because you want to try and find a point that is more than a year ago where they had both knowledge and disability from a psych perspective.
Yeah, and it's hard to fight those claims, because obviously you want to stop that before it even gets to the hands of the psych QME, just because cost, fighting that argument on that. But it's um it's definitely a frustrating point for employers, because I've seen a lot of times that I'm sure you've experienced, the post termination claims where they, work maybe for the employer a year or less than a year, and they come back with a CT claim plus a specific claim. Maybe the specific claim did happen, but it was, super minor. Like I think,
Like a first aid thing, a
yes,
first aid claim.
yes. But now they might deny the specific claim, but they'll accept the CT claim based on the time that the employee was hired. And that is definitely one of the biggest frustrations that I've seen, coming from the claim side. And the way I always explain to employers is that, like you said, California is a no fault state. So for a cumulative trauma claim to be accepted, you just have to you have to have 1% attribution to it. So it's like if you work for the employer and you had that, I want to say what I've seen from my end is usually a 3 month gap. So if you work for that employer for more than 3 months on the CT side, it's always accepted. I haven't seen anything below that, but I could see the argument for it.
I will say personally, I like to push it 6 months. But it's very easy for doctors to find a cumulative trauma in California, in Southern California. It's very easy for them to find it. And so the biggest tool that we have is discovery and trying to find out when these issues actually started and any prior treatments for the same body parts. That is the biggest way we can fight these. It's just, it's a no fault state. It's very difficult. It's very, very difficult. I will say it's easier for the people that regularly, they do their regular physicals, they go to the doctor here and there. It's a lot harder when you have those employees that never go to the doctor for anything, especially especially for like staffing agencies, if you're not provided health insurance, a lot of people just don't go to the doctor. And then when you ask them, if this was bothering you for X amount of time, why didn't you go to the doctor? I don't have health insurance. That's a fair answer. You're not really going to argue with that one too much.
We have a question from Lorena. It says, would an AOE COE investigation helps mitigate those claims if they were to be conducted on the onset of the alleged injuries? If so, curious, how often are AOE COE investigations conducted on the onset of a claim?
Would it help? It depends on the results of the AOE COE investigation. I like them. And keep in mind, my perspective is based on litigated claims. So I'm not saying go out there and conduct AOE COE on every claim, because some, might not be questioned as much. By the time I'm seeing them, it's because it's questioned, it's denied. I rarely see a solely accepted case unless it's just blowing out of proportion for whatever reason. So I'm assuming you're asking about the psych claims. If I'm wrong, please tell me. But it definitely would help, because when they do those AOE COE investigations, they are talking to coworkers, supervisors, people that had interactions with these employees that can give us insight to the day-to-day. Like, were they stressed out? Were they overworked? Or were they coming in late all the time? Or maybe they reported some other issues or stressors going on. And so in that sense, it does help.
Okay. And then for the public that doesn't know this terminology, what's an AOCE investigation? And then who is that? Who are those results shared with?
So AOE COE, we're looking for causation arising out of employment, cause from employment, causation out of employment. Usually an investigator is sent, an investigative company, and they know how to generate a report that can be confidential work product. And they know how to document witness statements properly. I do find that helps, because it will tell me which colleagues I might need to talk to in which I might not need to talk to. Maybe they didn't really know that much. Maybe the direct manager didn't know that much aside from just schedule and wages. But, Sally, who worked in the station next to the injured worker, got to hear about all the non-industrial stressors that person had. So it helps me also manage my time instead of calling everyone, to just call the people that had good information for that investigator. They will also provide information aside from name and position of the potential employer witness. They'll also provide contact information because, as we know, employees sometimes leave. And so I've had situations where I've had an AOE report that had a phone number and a full name, and I was able to find them. They had moved to the East Coast, and she was very willing to talk to me and even said she would testify at trial if needed. So it helps to have those to preserve evidence and information. And like I said, it's confidential, so it shouldn't be shared with everyone. You mainly want to share it with your legal team.
Yeah. And then let me ask you, because this happens a lot in both construction and staffing, where the ex-employee will file a CT claim and they are deemed permanent disabled for X amount of time, but they're working at a second staffing agency doing the same thing, and he's seen every Friday because people, the people talk, and he's posting on social media that he's working. So can you talk about your perspective of how an employer could, I guess, fight or protect himself, or create the argument as to why that person is not permanent and disabled?
Um, so that's a bit of a nuance, because permanent disability doesn't mean you're completely incapacitated. I'm trying to figure out how to word it properly, but it is a lasting deficiency that you have in that body part because of the injury. Now, that's not to say that, so
So let's say like the work status report says not able, not able to come back to work, or must not able to, because I've seen some crazy things where it says must walk and stand, take a break every 5 minutes. Like that's probably the craziest thing I've seen.
So I just want to make sure I'm understanding you. Are you talking about permanent work restrictions, like at the end of
No.
the case where everything's MMI, or are you talking about temporary work restrictions?
Temporary.
Okay, I just want to make sure we're talking about the same thing. So yeah, so again, without giving away too much, if there are work restrictions and the injured worker is working for a different employer, and you suspect that the restrictions are not being followed because maybe we have information that he or she is working outside of those restrictions, I would probably look toward trying to join the subsequent employer, because it would probably be my position that they are aggravating the injury or making it worse. Again, you'd still have to prove that up. You might have to ask a QME or AME or PTP to comment on that. You can use a deposition also to do that, but that is something to consider. I've seen other strategies like creating a subsequent cumulative trauma. I've done that a couple of times, where like you have your end date, right? When your employment ended or whatever the date of injury is. But then you can also look to see if there's another cumulative trauma after the fact from when they started working at that other employer and ongoing. There's another strategy that can be used to maybe propose that there could be an ongoing cumulative trauma date because there was no gap in the work that they were doing. If they're just going through the same job duties continuously. So there's a lot of things to try. I'll give you those three. strategies for free.
Yeah. Yeah, because obviously, that's another thing that's very common here, especially with the ones that have gone from, company to company and have the history of doing that.
Mhm.
And what I've seen is either the carrier goes, well, we don't want to spend money on an investigation, because we don't want to add up the bills, or the employer is really adamant about it and they know, and it might help them out, but just knowing that it also gets complex because, right, um, you could always make the argument that the the AOCUE investigation says something completely different, or it does support those facts, but still, because an investigation is brought in, doesn't mean that whatever they're capturing there is going to follow or deny what's on the work status.
Yeah, I think if it's a highly questionable claim and everyone's a bit suspicious of it, it would help to consider having an AOE investigation.
Mhm.
Or if the HR person or the supervisor does say, hey, there are these issues, I recommend getting it because you can at least document whatever these potential employer witnesses have, the information that they have while it's fresh in their mind, versus 3 to 5 years later coming back to them and they go, I don't really remember if they said that this was going on. I think that's what they said. So the sooner you can lock in that information, the better. But I do know it is an added cost. So I wouldn't recommend doing it on all your claims.
Right. Definitely, it is an added cost, and it's definitely different when you are in a standard market versus if you're self-insured and you're, running the cost on your own
Right.
on a captive. Usually, like when that's more popular and it's used, it's usually when, they're self-insured because, they're paying out of pocket, and or they're in the captive. But definitely when you're in the standard market, it's an uphill battle. It might be an uphill battle between the carrier because, again, like I said, it's additional costs to that.
Yeah. Also, I'm glad that you brought up the subsequent employer because don't forget about the concurrent employer. Sometimes they're working for two staffing agencies or they're working with three of them and they're just getting placed, depending on their need. So keep that in mind
Yeah.
also because you might need to bring them to the party. It can be fun. A fun party. Everyone just come.
Yeah, and I mean, it's unfortunate because then anyone who's named on that lawsuit, that claim gets open under their claims. So when they get their XMOB worksheet, the loss runs, you're going to see that claim number, that employee, and hopefully your broker and your carrier are working on your behalf and they're trying to control the reserves. But if they're not, you're going to get stuck with this nasty, overly reserved claim.
And I always go back to admin because, carpal tunnel is just there. It's
Yeah.
prevalent. So, but if you're working with different staffing agencies and you're being placed for all these admin jobs or clerical jobs, I mean, if you're doing very similar duties, performing very similar duties for multiple employers, it's only fair, I think.
Most definitely. And is there anything that you would advise staffing agencies to do right now to, I guess, better protect themselves or have better build up their case for their defense attorneys?
I'm going to sound like a broken record because I've told you this so many times. Always communication and always documentation. Um, I mean, we touched on verifying insurance for whoever's providing the coverage, um, keeping copies of contracts between the companies that you're working with to send these employees out to them. Make sure you have those contracts that outline everyone's responsibilities and duties. Um, Make sure you have all your payroll and wage statements because sometimes it adds costs. It adds litigation costs when your attorney has to be calling the payroll company and asking for it.
Oh,
when it's free, if you're paying the salary of the person that works for you that can get that information, I imagine it's cheaper if you get all the personnel documents yourself versus the legal team having to get it. So the more you can get us as far as documentation, the better. If you can give us, the contracts, the wage statements, the applications, because then we can get a job history. That's something, if especially if you're trying to keep costs down and you don't want depositions to be taken because those are expensive, having the job applications there, that they usually have an employment history, or a lot of times staffing agencies will help them create a resume if they don't already have one. That's all information that we would try to get at a deposition, so we can get that for free from you. So document, communicate, those are the two best things you can do.
yeah. And then depositions, yeah, like just like you mentioned, they are very expensive, and they usually get dragged out. Maybe, well, it depends how eager the applicant attorney wants to settle. But I've seen situations where they kind of sit on it, and they're like, okay, we're going to depose, do the deposition maybe 2 months from now, and then the applicant attorney or the employee reschedule. And that's kind of like when they're trying to kick it down. They're just like, oh,
Mm-hmm.
like they're not that interested in it, and it just gets dragged on. Or they're trying to push the carrier to settle for a nuisance value because they know they don't have an argument. So they're just like, all right, we'll just kind of kick the can down the road and ask the carrier for this value, and kind of we both just walk away. But now the popular thing, like you said, what I'm seeing too is that these applicant attorneys are like, no, we want ortho. We already have him treating. Like you'll literally get the lawsuit, and then 3 days later, or the next day, you'll get the QME report from the ortho.
Yeah. And then, once you have causation on any of the types of injuries that they're alleging, then it's a really an uphill battle, because now you're trying to defend against all the other ancillary specialties that they've created, whether it's neuro or psych or internal. It's just tacking on to it. So
Yeah,
you want to get it as early as you can.
most definitely.
But the
Most,
best way to do that is with information and documentation. So if you've told us everything, we can go in as armed as we can possibly be.
yeah. All right. Well, you guys, we're almost coming into an end. If there's any other questions, feel free to comment them down. And Daisy is tagged on the LinkedIn event. So if you guys want to follow her, go ahead, follow her. She's also on Instagram. But here on LinkedIn, for the employers who are interested in connecting with Daisy, maybe having her as your legal defense or asking her for advice, feel free to follow. And then Daisy, where else can people connect with you?
You can always go through www.legaldaisy.com. You can connect with me there. And if you send a request through there, it goes directly into my email box. So I'm always on LinkedIn, I'm on Instagram, and on my website.
Awesome. And is there anything else that you would like the audience to know before we close this down?
No, I think everyone just stay safe out there. It's hot, it's wild. Just, we have a heat wave, things seem out of control, but everyone stay safe out there.
Yeah, definitely stay safe. I mean, there's a lot of commotion. There's a lot of, with the whole immigration thing going on, there's a lot of chaos. But we're here to, serve you guys, make sure that you guys are protected. And Will and Lorena, thank you so much for listening and for asking your questions. Really greatly appreciate you guys. So if you guys have any further questions for Miss Daisy, go ahead, add her, email her, and contact her. And we will see you guys on the next time. Bye.
Bye.